The question I'm trying to answer in reverse incorporation of state constitutional law is, what can state constitutional law tell us about the federal Constitution? And my answer is more than people think. The thesis of the piece is that federal interpreters of the federal Constitution can and sometimes should look to state constitutional law for guidance when they're confronted with questions that the state constitutional interpreters, that is state courts, have experience with the federal interpreters don't. So an example. In 2008, the Supreme Court interpreted the Second Amendment to guarantee an individual right to bear arms, that is, a right to bear arms independent of militia service. Now, this was a new interpretation of the Second Amendment, so there wasn't a lot of federal doctrine on the point. And since then, federal courts have struggled with basic questions like, what should the standard of review be for evaluating the constitutionality of gun control? So where are they going to look for guidance? I argue in the article that they can look to the state courts because, as it turns out, state constitutions have guaranteed this same right for decades and sometimes centuries, and there is a wide and remarkably uniform body of state constitutional doctrine addressing that very question. It turns out that the state courts have almost unanimously agreed that the standard of review should be a form of intermediate scrutiny they call reasonableness. So I argue federal courts, not having any guidance from their own doctrine, can look to this body of doctrine, which is addressing the similar question. Now, in order to make this argument work, I have to show both that state constitutional law and federal constitutional law are similar and that they're different, because if they're the same thing, then there's no benefit, and if they're too different, then there's no point in trying to compare. So the piece starts by telling a little bit of a story about the relationship, the underexplored relationship, I think, between the two. As it turns out, state constitutional law and state constitutional rights guarantees are in many ways the basis for rights, constitutional rights in the American tradition. Before the U.S. Bill of Rights, with all its familiar guarantees, was written, all of the guarantees we know, free exercise, free speech, the restrictions on search and seizure, had pre-existing guarantees in state constitutions, which were then adopted into the federal Constitution. And in fact, even after the Bill of Rights was ratified and the Constitution was ratified, those state constitutional guarantees were, for almost 175 years, the basis of rights guarantees in the United States. Things got a little complicated in the 20th century for two main reasons. One, the Supreme Court started to incorporate the federal Bill of Rights against the states. And what that means is they took the First Amendment, eventually the Second Amendment, the various guarantees in the Bill of Rights, and applied them to the states and said that even though the First Amendment says Congress shall make no law, actually it also binds the state governments. And then, particularly in the era of the Warren Court, those federal guarantees were interpreted very broadly. And that meant that the federal floor came very high. There was a broad and applicable to states rights guarantees. Now, this meant that the state constitutional guarantees sort of fell into the background because, as a result of the Supremacy Clause, the federal guarantees are the floor. Now, states can exceed it if they want, but they can't go below it effectively. So, for example, the federal constitutional doctrine on the First Amendment says that obscenity is not protected by the First Amendment. Now, all the states, except for Delaware, it turns out, have a First Amendment equivalent that protects free speech. Now, the state courts could, if they wanted, say that, okay, the First Amendment of the federal Constitution doesn't protect obscenity, but our state Constitution does. In other words, they could go above the federal floor. But because the Warren Court had set that floor so high, there were very few state courts that would go above it. So for a long time, there wasn't a lot going on in state constitutional law. It just wasn't relevant. If somebody wanted to make a constitutional claim, they would just make the federal claim, and that was usually enough to win. But things changed in the 1970s, or perceived to change anyway. The Berger Court was perceived as rolling back the federal guarantees, in other words, lowering that floor, particularly with regard to criminal procedure rights. And so some people, most prominently Justice Brennan, who himself was a former state judge, argued that the states should reclaim their constitutional tradition, their constitutional heritage, and interpret their own guarantees as higher than the federal. Whether this resulted in any kind of actual change to state constitutional doctrine is a little bit tough to say. As it turns out, most states tend to still interpret their constitutions in lockstep with the federal document. In other words, state courts will cite the federal constitution, they will cite U.S. Supreme Court cases, even though those are not binding on them. The state courts are the final interpreters of their own documents, and they can decide what they mean, even if it is contrary to federal law. Now, it won't have any effect if it's below this floor, but they are, in many ways, independent. So the question I'm trying to address in the paper is, why doesn't this relationship go the other way? If all the state courts are doing is looking to the federal courts for guidance, which they're not required to do, why don't the federal courts look back to the state courts for guidance? And it turns out they don't very much, and I think that's puzzling, and that's one of the puzzles that I try to address in the article. The Supreme Court has increasingly, or certainly prominently in recent years, cited to international opinions, sometimes even to law reviews, and so the fact that they're not engaging in this sort of intranational comparison, I think is interesting, particularly given that we have a very prominent commitment in our constitutional tradition to federalism and to the states. And so if we say we're committed to the states and their constitutional traditions, why aren't the federal courts looking to what that doctrine actually says? If we believe the states are laboratories of experimentation, as Justice Brandeis put it, why aren't the federal courts looking to the lab results? So in the article, I try to explore those few examples of the Supreme Court or the federal courts actually looking to the state courts, and I argue that they should do that more often.